This is Remedies, Section 8, Class 2. And what we're looking at are different agreements that require an employee or others to forego their rights of class actions or be able to pursue class actions, these agreements that have provisions in them either that deal with class actions or arbitration. And what we're seeing, as we discussed last time, are more and more situations where the court is allowing parties to contract with respect to what their rights are in the event of a dispute, and whether they happen to be business adversaries, which historically was always likely enforced, to whether it is an individual and a business, which we saw in Shute. Despite the disparity in bargaining power and all of that, the courts enforced it. And now what we're seeing, the more recent trend, is with respect to employees and their employers. And obviously there is significant disparity of bargaining power there. But the fact is that the consumer or the employee oftentimes enters into these agreements, and at the end of the day they are likely responsible for their own choices. But Thiessen was a case from 2001 where the court actually looked at whether the employees could band together to pursue their discrimination claims under the circumstances. And the problem with, and we saw it more recently in the Walmart case, is that when employees try to band together to bring their, in Thiessen's case it was an age discrimination claim, it's oftentimes hard to have the type of communal proof necessary in order to satisfy the 5 standards with respect to maintenance of a class action. And so when we start to think about these claims of discrimination, wage disparity, and the like, to try and meet the commonality, numerosity, typicality, adequacy, and manageability factors, it becomes significantly more difficult unless you've got a uniform document or proof of company-wide policies that actually create the illegal activity. But so what happened in Thiessen is that the court initially did in fact certify the class on the age discrimination age discrimination claim, saying that there were similarly situated employees. The defendant opposed that and sought decertification of the class action in order to try and defeat the employees' claims. And so what we ultimately had happen is that the Court of Appeals took a harder look at that case and determined that there was a group so similarly situated that they could, in fact, likely at some point be able to show a connection between the discriminatory practices and the adverse employment actions that the plaintiffs were alleging. And so while it's not common, and it may be even harder after a case like Walmart, the fact is that that some of these class actions may be maintained. And this, at least in part, is what brings us to the next level, which is why more and more employers are asking employees to waive their right to participate in class actions and other collective actions against their employer in order to maintain their employer relationship. And that's where the court then has to wade in and decide what is necessary there in order to enforce such a binding agreement. Now, there's one other very interesting point about these, and we don't see it that often, so I want to address it, and I want you to think a little bit harder about it, because we're seeing this as well more and more in significant pieces of civil litigation. And that is the spoliation of evidence, the destruction of evidence. And in fact, you as an attorney have an obligation to preserve evidence once litigation has begun, or even when you know that the situation means that it is likely that litigation at some point will follow. And so, what happens under the circumstances where, especially today, it's relatively easy to dispose of evidence, especially soft copy evidence. But is that really treated much differently than when an individual in the past put the documents through the paper shredder? But what happens in these cases when you're trying to show spoliation of evidence and how it came about, and is that, well, how do we get access to the information to show that either it was purposeful, and some states would require you to show that there was a deliberate destruction or spoliation of evidence. Others, like Massachusetts, say it really doesn't matter whether it's a deliberate destruction or a negligent loss of evidence. Either way, there's a presumption that the evidence that was lost was harmful to the person whose possession it was in. And so I think that's what the law says in Massachusetts, but as a practical matter, and especially if you think of how the jury would receive it, we oftentimes might be a little more willing to excuse the negligent loss of evidence as opposed to the deliberate and willful destruction of evidence. It shows a much more consciousness of guilt that a jury is likely to find more abhorrent and likely punished to a greater extent with a greater award of damages than if they just thought it was negligent. But in many jurisdictions, the spoliation of evidence, whether it occurs deliberately or negligently, really doesn't matter because there's a presumption that the evidence that was lost was harmful to you. But what they wanted to do in Thiessen, and I'd ask you to take a careful look at the last part of the case, because they sought to depose defendant's counsel. And this is done sometimes because oftentimes now defendant's counsel or the corporate counsel representing the entity oftentimes has been involved, has been sought for advice throughout the course of the pre-litigation goings on, and many times is directing the activities of the corporation either to assist them with to avoid potential damaging judgment. I'm sure they would argue that they're doing it to make sure their clients' actions conform to the law, but I've seen this many times in many situations, and I think it's a very fine line that some of these counsel walk when they are working with the party in potentially involving the loss of evidence or involving the entity taking actions that likely violate the law. We're not necessarily talking about the crime fraud exception to the attorney-client privilege, but that's certainly raised by some of these issues. But what happens in this case is that the plaintiff wants to depose the defendant's corporate counsel. And what they're saying here is that the corporate counsel was involved in this, what they call the blocker policy. And that's what led to this age discrimination claim, was the company-wide policy with respect to preventing older employees from advancing. And so what they said is that this lawyer investigated the company's blocker policy, and it was her who, for all intents and purposes, directed the purging of corporate documents pertaining to the blocker policy. And this is a legitimate problem if you think about it. I've had cases like this. I've had cases of sex harassment and hostile workplace. And, you know, if you think about it, the company says, well, we need to get rid of these offensive cartoons and jokes and the like. Well, are you really purging the system of offensive material so it can't be further disseminated? Or are you doing it in order to make the parties' claims harder to prove? And that becomes a legitimate issue, and there are arguing points on both sides. But here, there's no good reason to destroy the blocker policy documents, there may be a good reason to issue directives that the policy can no longer be effective and never should have. But of course, that gives the plaintiffs significant proof that the company was engaged in an illegal policy to begin with. So the argument here is that in response to the charge of age discrimination filed by the plaintiffs with the agency, EEOC and the like, they directed employees, so she directed employees, Sarah Gorman, to purge the company files of documents pertaining to the blocker policy. They plaintiffs argued that under those circumstances they have the right to depose Gorman regarding the cover-up activities, despite her status as corporate counsel, because she had direct involvement in this case as a witness, and therefore they should be able to depose her regarding the information and her activities with respect to what the plaintiffs allege were illegal acts of discrimination committed by the defendant. And what you have to remember here, and so they were looking at whether this was appropriate for the trial court to deny the plaintiffs the right to depose the defendant's counsel. And in order to do so, though, when reviewing it, they look at it for clear error. And that's a pretty hard standard to reach. But what they've set here is a standard for you to start to think about, that when you believe counsel, corporate counsel or present counsel, has been involved to the extent in the case that they now have information that is essential to the presentation and likely success of your case, that recognize that the standard is relatively high for proving that. They set forth a three-part standard here that I think is pretty typical of what we'd see if you were making the same presentation to a trial court, arguing that you must have this information and must be able to obtain it through their counsel. It's only in limited circumstances where you will get access to this information and get access to counsel at any rate. And what you need to show are three things. The first one is that there's no means exists to obtain the information other than to depose opposing counsel. So it's in essence a means of last resort. And this is a legitimate standard that the court imposes, because oftentimes there should be other ways of getting the information other than the fairly intrusive interrogation of counsel. Obviously, the interrogation of counsel also raises additional issues that you would be involved with respect to, there'd be lots of claims of privilege. They'd be running back and forth to the court with respect to their rulings on those issues. It's not something you would do lightly anyway, but recognize that before you start to think about traveling down the road, it's always best to try and figure out if there's any other way to get this information, and if there are other means, then you should pursue those first, and only as a last resort look to ask the court to do this. But at the same point, oftentimes, I've seen it many times in cases where the lawyers have put themselves far too much involved in the case, so that they have crossed the line between simply being the lawyer and now have become a key witness as well in the case. But make sure you can't get it from anywhere else. 2, the information sought is relevant and non-privileged. And that's also another hurdle and a bar to get past here. A lot of this starts with making sure you've got a privilege log with respect to activities and information that is being withheld, so that you have at least a base of knowledge there as you start to dive deep on this. But you're going to have to get past the attorney-client privilege. Some states have the laws that talk about the difference between providing business advice and providing legal advice. Business advice not being privileged, legal advice being privileged. And there are situations where many times now the corporation is smart enough to stick a lawyer in the room for business meetings. and give the conversation, or attempt to give the conversation and the exchange of information, what we call a privilege bath. Since there's a lawyer in the room, they're now going to argue all of it was an exchange of information for the purposes of seeking legal advice. And that's a pretty tough bar to get past. But there will be situations where, if you've sought proof and have been able to obtain some information from other sources, that you may be able to show, at least initially, to the court, such that they will schedule a hearing of some sort, that the information sought is non-privileged. Relevant is pretty easy to establish, as you know from the rules of evidence. And lastly, the third point is that the information is crucial to the preparation of the case. And again, this really is just talking about how highly relevant it is and how necessary it is to obtain it. I think the biggest problem that Thiessen had, and oftentimes the court has, is satisfying standard number one. Is there really no means otherwise to obtain this information other than opposing counsel? It is a means of last resort, not first resort. But it is, and unfortunately, I've seen it more often recently, that counsel has precariously entered the gray area where it is not clear that they are solely counsel, as much as they have become an interested party in the successful defense of the case. And that we all have to be careful about, but especially as lawyers on the other side, we've got to be careful to try and make sure that the information is still accessible. And the first attempt is get it from other means. Get a sufficient basis where you have enough information to show the court that your case deserves more. Under those circumstances, you've got a better chance of obtaining that information. So that was Thiessen. And the last case in Section 8, although we have a couple of cases, more recent class action to talk about. The last case is Circuit City versus Adams. And Circuit City versus Adams is an interesting case as well. And the reason Circuit City versus Adams is an interesting case is for the same reason as we start to talk about when the court looks at these required arbitration, required resolution of the case by means other than resorting to court, juries, and resolving those cases in the normal means of how employee-employer disputes have been resolved historically. But Circuit City versus Adams, same year as Thiessen, is an individual who was employed by Circuit City, and in the employment contract that he signed with Circuit City, that he agreed, Adams agreed, that no matter what the dispute was for, they would be required to bring all employment disputes to arbitration. The clause specifically said it really didn't make a difference what the claim was, whether it's continued employment, candidacy for employment, or cessation of employment. Exclusively and final binding arbitration shall be brought before a neutral arbitrator. Adams had an employment discrimination suit, much like Thiessen, and what he wanted the court to be able to resolve it, not an arbitrator where he didn't think that he would do as well or it be as open. And that's the other thing to start to think about with respect to employment practices and the whole issue of compelled arbitration. Not compelled, and I say that a lot, but it's not compelled. It's only compelled by the court after the parties have voluntarily agreed to it. And so what the court will do under the FAA and under your contract that you've entered into is now compel you to carry out the terms of the agreement you reached. And so these employment agreements that have these required arbitration provisions in them in Adams, they were saying, well, this isn't right for discrimination claims. It's also, if you think about it from a policy standpoint, it's not right to have this private body of law of disputes that we really don't know anything about. You can go on Pacer for the federal courts and find the name of every case filed in that jurisdiction by both plaintiff and defendant. You could look up and see how many times Home Depot has been sued for discrimination. If you wanted to go through the various circuits and the like, you could see whether an employer, for instance, is a, quote, good employer or a bad employer. But when you have arbitration, it is a private, secret dispute resolution service. And one could argue that claims of discrimination, claims civil rights violations, things of that nature should be available for public inspection so that the companies would more likely do the right thing as opposed to try to keep their violations of the law secret and therefore continue those practices even if they were to harm certain groups and the like. But at any rate, the provision in the contract, and I actually had a chance to review the Circuit City employment contract, even for hourly workers. It's seriously, the agreement itself is probably about 3/4 of an inch to an inch thick, even at the time for hourly workers. Circuit City has since gone out of business. It's equivalent to Best Buy or companies like that. Large electronics retailers and the like. But so they had an extensive agreement, and this person was a salesperson. But there are a lot of people that would, a lot of law students that would have trouble deciphering an inch-thick employment agreement in all of its complexities and the like. But that's what was at work here. And the question was, would the court require the employee now, who really had very little bargaining power when they seeking a job, to be bound by the arbitration provision that the employee was aware of and signed the employment agreement, even if it might work, not just a significant hardship, but in essence argue that it's unconscionable under the circumstances for claims like these, where we're saying that I'm being discriminated against, and now even though I've alleged these claims, I don't get a judge or a jury, more importantly, to examine the defendant's practices and decide. So what did the court do in the Circuit City case? And this was 2001, and this is why when we come forward 18 years, we see that these provisions with respect to required arbitration and in essence a waiver of the initial court process is enforced, is because the Supreme Court in Circuit City said just that, is that these agreements are enforceable. These agreements can be used against the person who signs them, and whether you're an employee or the employer is free to ask for and get these provisions. And if you don't want to sign it, you don't have to work there, but once having signed it, you're going to be bound by it. And that becomes a problem for all employees, as we're going to see. Now, as we come forward from the Adams versus Circuit City case, the question becomes, well, where else are we going to see these? And from our own experience, we know that they are in virtually every online agreement you've ever clicked through and said, I accept. They're in your consumer agreements, your not just for arbitration, but the trend then became, well, if we can do that, let's see what else we can put in there. And then in your the newest extension of this is the waiver of participation in a class action. And we've got a couple cases that you have to think about there that become very important when we think about the inability or your agreement being specifically enforced, that you said you wouldn't participate. Not only would you not go to court but arbitrate the agreement, but that you won't even participate with others who might go to court and bring a class action under the circumstances for illegal activities. The biggest case in the consumer context of all of this was your cell phone case, AT&T versus Concepcion. What happened there is that the Supreme Court examined whether you could have, in a consumer agreement, a waiver of the individual's right to participate in a class action. And if you think about it, with cell phones, this expense can be high, but it still may not be high enough to justify hiring a lawyer, paying a lawyer an hourly basis, and pursuing that to your satisfaction. That's a very expensive process. But when you think about how many cell phones there are by even each provider across the country, those are the types of cases that historically would have been handled by way of a class action, because the amounts themselves might be relatively modest, but in the aggregate they are huge. Well, what AT&T did, and what other cell phone providers do as well, is put a waiver of class action provision within the agreements you sign when you go get your phones and your cell service. And at some point, the Supreme Court examined that and said, geez, how can this be fair in consumer agreements to have consumers waive their rights to participate in a class action? This should be unenforceable under the public policy provisions, at least with respect to consumers. But just as Shute had warned, or Schutz had shown us years earlier, the fact is that this is where the Supreme Court was going. This is where the law was going. The fact is that in AT&T versus Concepcion, the court said no. In consumers, just like all the rest of us, can waive their rights under the circumstances and not have the ability to participate in a class action. Now, the court was careful in saying that this policy must be clear to the consumer. There must be specific language that would show that they are waiving such provision. And the I accept button has to be clicked on. And in some cases, if you wanted to be even more careful, that to make sure that the person has to at least review those pages prior to clicking I accept, if you want to make sure that it's in essence bulletproof. But the fact is that that I accept button is just as at the end of the day enforceable, as long as it is clear what these provisions are and that the person it's made known to them that they are waiving some pretty significant rights, because these waiver clauses are incredibly powerful tools. Companies are using them to reduce the risk of significant and onerous consumer class action litigations, and can be debilitating for a company, both in expense and time and risk. So that's why the trend is to put these in there. And frankly, if you were a lawyer representing a company with any significant customer base, you'd probably be negligent not to put such clauses in these days. Now, there's an argument that it's not necessarily a good business judgment because it'll turn off some consumers and the like. But especially if you were dealing with a web-based service company, the fact is that you could potentially be sued by anyone, anywhere across the United States. And that if you have a significant amount of customers, you could potentially face a class action in some distant forum that is going to be potentially a break your business piece of litigation, just on the basis of the cost to defend, much less the judgment that could follow from that class action. The fact is, it's a good business decision to put these clauses in, and as we've seen over the course of the last 2 decades, the court will likely, almost definitely, enforce those provisions as well. Now, lastly, we have one other point that I want to make, and these are the more recent Supreme Court cases from just the last few years, and that's Epic Systems versus Lewis, Ernst & Young versus Morris, and the National Labor Relations Board versus Murphy Oil. There was a split in circuits as to whether class or collective action waivers, that you won't participate in a class action or you won't undertake collective action against your employer, whether those types of provisions violated the National Labor Relations Act. This requirement that whatever problem you have, you agree that it will be resolved through arbitration. And there is a question about whether it's a class action or a collective action brought against your employer, whether that, in fact, intrudes into the National Labor Relations Act. Well, as you might guess, the court, in a 5-4 decision authored by Justice Gorsuch, said that because of the Federal Arbitration Act, which we've talked about last time, arbitration agreements that provide for individualized proceedings are enforceable, and they do not violate the National Labor Relations Act. And so if you've got any work-related claim and you have such a provision with respect to arbitration, then instead of going to court, you're going to have to file and proceed through arbitration. And this does not violate the Federal Arbitration Act in any way. And so you're stuck with, in essence, losing your right to a jury trial. But again, when I say stuck with losing your right to a jury trial, this is a provision that you signed likely at the time you started your job. The court long ago gave up this, as they saw it, old notion of equal bargaining power and free to reject the provision. You know, that ship was sailed, no pun intended, in shoot. The fact is that if you're an adult and you make a knowing and voluntary waiver of your rights to go to court, and you agree to arbitrate or you agree to not participate in any form of class action, or not to participate in any type of collective action in these cases against your employer, then the court is going to hold you to that promise, to that agreement that you made. And again, so if we're thinking about being good lawyers, then good lawyers who represent employers are going to put these provisions in their agreement. And again, prevent the employee at their agreement from going to court in order to pursue their rights, that whatever rights they have would have to be pursued in arbitration, and that is not violative of the National Labor Relations Act. And so these are very recent cases where the court has further made inroads to this whole point about the contract is the contract is the contract, and if you agree to certain provisions in those contracts, knowing and on a voluntary basis, and you've signed them, and that's important that we make sure that its signatories to that agreement are likely bound by that agreement. Non-signatories shouldn't be. But if you are, and you have agreed to arbitration, or you have agreed to not participate in a class action, or not participate in collective action, in essence, waived your rights, as some would see it, to due process and the freedom of association with others, and to pursue even civil rights claims and age discrimination claims and the like. The trend in the courts these days is you're going to be pushing a big rock up a big hill to try and have those rights vindicated in a court. You're likely limited to the forum in which you agreed to go to, even as you see that might have been a very bad decision all those many years ago. This concludes this class, but these are important things for you to think about, and especially as you start to think about the trend in which we do business now. So much of it is online, so much of it is clicking buttons where I accept. And if you really looked at the agreements, whether it's Facebook or Instagram or Snapchat or Craigslist and all the rest, where you're selling and buying and God knows what, I hope you wouldn't be surprised at the rights you've given away without looking at them, because that's where the business is conducted. And with these cases in mind, you can be sure that most companies have made sure that their agreements are giving them all of the rights that the court has now agreed that if the contract says they have those rights, then the likelihood is those rights are enforceable.